The CCJ in its ruling on Tuesday declared that the clauses of Ghana's constitution, which makes it illegal for a man or a woman to appear in public dressed in clothing of the opposite sex for an improper purpose, is unconstitutional. The ruling by the court also ordered that Section 153(1)(48) be omitted from the laws of Ghana and that costs are to be awarded to the appellants in the appeal before the CCJ and in the courts below. The founder of SACID, Joel Simpson, deemed the ruling of the CCJ a step in the right direction for human rights in Ghana.
We recognize that it is essential to, and the court did recognize this, that it's essential to human progress that there's a place for contrary ideas and opinions to be peacefully contended, and this includes a person's mode of dress, including when they're expressing their gender identity and gender expression.
The CCJ also expressed concern over the way magistrates handle matters involving transgender individuals. According to the court, judicial officers must not use the bench to proselytize, whether before, during, or after the conclusion of court proceedings. Secularism is one of the cornerstones upon which the Republic of Ghana rests. End of quote. Attorney at law Nigel Hughes opined that the ruling of the CCJ is an historic one. He stated that fundamental human rights were impinged by the Savings Clause, which most times protected archaic laws.
What the CCJ did in their decision today was to severely restrict and narrow the application of the Savings Clause to protect all those offensive parts of the statutes that we have that were there, like this particular section, since 1893. What, amongst the things that they said, which I think is of signal importance to practitioners of the law, was the Savings Clause does not protect offensive legislation where it offends the separation of powers. And I think that's a significant development.
Javon Vickery, HGP Nightly News.